Intellectual property and other intangible assets are estimated to be worth nearly $6 trillion worldwide, and protecting this value is key to making sure your innovations aren't exploited or monetized by someone else. But globalization and emerging technologies are just some of the things making IP protection and enforcement more complicated. To hear more, let's meet two people from one of the world's leading intellectual property firms, Marks & Clerk. We're talking to International Chairman Maureen Kinsler and partner Mike Gilbert. I'm Sarah Lockett. Welcome to the Business Debate. Maureen and Mike, welcome to the London Stock Exchange studios.
Hello, nice to be here.
So Maureen, as I mentioned in the introduction there, globalization and different technology coming online all the time is making intellectual property protection more complicated. How?
Globalization means that increasingly supply chains are cross-border, so international supply chains with products moving through multiple different countries, and emerging technologies such as 3D printing and artificial intelligence know no boundaries. Now, patents are highly territorial, so a patent in the UK only has effect in the UK, and a patent in the USA only has effect in the USA. So we have to be very mindful of where our clients are, their products, how they're made, how they're fabricated, how they move through different territories as part of the supply chain, and who's doing what and where. And this is a really core part of our job to help our clients navigate through this.
And one of your challenges also is that sometimes people don't really know what IP protection is, why they need it.
Yeah.
What do you tell them?
IP protection really is a mechanism for generating value from innovation and creativity. The start of it is always innovation and creativity. Patents protect technical innovation, trademarks protect branding and commercial innovation, registered designs protect the look of a product, and copyright protects artistic and musical works. So fundamental to IP is this generation of ideas and this creation of new works. And IP is about generating value from that. And
what do you say, Mike, about that?
Yeah, absolutely. And indeed, the value of IP today is absolutely extraordinary. About $6 trillion of intangible assets, the vast majority of which is based on the value of IP for companies. So a very important part of the balance sheet for businesses.
And clients don't just have to stop everyone else using their discovery, do they? They can license it. But what are the factors that would lead them to license as opposed to just patenting for themselves?
Sure. Well, people do patent for themselves and do make their own products according to their patented inventions, but also there are a number of manufacturers that will outsource their manufacturing using the fabless approach to business.
Now, you're not saying fabulous, are you?
I'm not saying fabulous, I'm saying fabless.
Which means?
Which means there is no fabrication. And there are also ways of licensing the technology if the patents are to do with platform technologies, and that can result in a serious income stream coming in for those businesses.
And how soon in the process, Maureen, do you advise to start thinking about filing for protection? Because is it true that maybe some academic institutions are slow to file, would you say?
Well, the key thing with patents is that you must file before you disclose an invention. So we would always advise filing sooner rather than later. Universities are becoming more familiar with IP, and some actually are very good at protecting their intellectual property, but there is still a huge push in universities for publication. The academics are rated on the number of publications they have, and actually that can be very detrimental to the patenting process. So sooner rather than later, I think, is the mantra.
And you'd agree with that, would you, Mike?
Absolutely. I mean, both in terms of monetising the value of the IP from those institutions, but as well as litigation strategies as well, making sure that there is no prior disclosure or unfortunate disclosures which can be fatal to any protection that is being sought through the courts.
And we've got to mention the B word, haven't we? Brexit. What effect is Brexit having?
Well, in the IP world, it is obviously creating a huge amount of uncertainty, like it is in many other aspects of life. What we are trying to do is to guide our clients through the times of uncertainty, and that uncertainty is not just until up to Brexit, but probably for many years afterwards as well. But we at Marks & Clerk do have established businesses in mainland Europe, so in Luxembourg and France, where we've had businesses for the last 20 years. And we are there to help our clients and guide them through the Brexit process. So while the UK is leaving the EU, Marks & Clerk is very much not, and is still very much there.
And how enforceable is intellectual property protection, and what can organisations do if they have filed but they then find that it is infringed?
Yes, well, that happens in many occasions, and more recently there have been many patent infringement suits that have been brought in China and in India, where those courts are now getting far more sophisticated than they ever used to be. And the key is for people wanting to enforce their patents to identify their trusted advisors to guide them through those complicated processes.
So it is possible, Maureen, to protect your invention or innovation, even in far-flung parts of the world, as Mike says.
Oh yeah, absolutely. And it really is key to many companies' business strategy to make sure that protection is in place.
Well, Maureen and Mike, thank you very much.
Thank you.
And join us next time when we'll be discussing the latest innovations in mergers and acquisitions and executive education. But for now, from me, Sarah Lockett, at the London Stock Exchange Studios, it's goodbye and thanks for watching.